We are interrupting your regular feed with a critical breaking news alert that fundamentally changes the future of legal immigration to the United States for millions of families around the globe. Welcome to Immigration News Desk, your trusted source for the truth behind the headlines. Tonight, we are analyzing a leaked internal document that has sent shockwaves through the Department of State and the immigration legal community, revealing a plan to indefinitely suspend immigrant visa processing for nationals from 75 specific countries starting on January 21, 2026. This is not a drill, and this is not a rumor. Major outlets including Fox News have reported receiving access to internal State Department communications that outline a massive freeze on green card processing that is arguably more sweeping and significant than anything we saw even during the height of the global health crisis in 2020. If you have a family member, a spouse, a parent, or an employee waiting for an interview at a U.S. embassy abroad, you need to listen to every single word of this report because the government has found a new justification to shut down the pipeline, and the rationale they are using is one that is incredibly difficult to fight. The State Department has issued a statement on the social media platform X, and the details emerging from leaked internal memos suggest that this pause is based entirely on the concept of public charge and a new initiative to prevent what they are calling the extraction of wealth from the American taxpayer. According to the reports breaking today, the United States government is preparing to implement a hard stop on issuing immigrant visas. That means green cards processed outside the U.S. for 75 nations deemed to have high rates of migrants utilizing public welfare benefits. The internal logic, as described in these documents, is that the freeze will remain active indefinitely until the United States can ensure, with absolute certainty, that new immigrants from these specific regions will not become a burden on the American economy. This is a seismic shift in policy because it moves beyond individual assessment and places a blanket ban on entire nationalities based on statistical data regarding welfare usage. We are looking at a start date of January 21, 2026, which is exactly 1 week from the date mentioned in the documents, creating a microscopic window of time for anyone currently in the final stages of their process. The sheer scope of this list is staggering, covering vast regions of the Caribbean, Africa, Eastern Europe, and South America, effectively severing the family reunification process for hundreds of thousands of people. To understand the gravity of this, we have to look at the justification the government is using. They are citing public charge, a term that has existed in immigration law for decades, but is now being weaponized in a completely new way. Historically, the public charge rule meant that an individual immigrant had to prove they wouldn't rely on the government for subsistence. We already have a system in place for this. It is called the Affidavit of Support, where a U.S. sponsor signs a legally binding contract to be financially responsible for the immigrant. However, this new directive suggests that the current sponsorship system is no longer considered sufficient by the powers that be. The State Department's post on X explicitly stated that they will pause processing from these 75 countries because their migrants take welfare from the American people at unacceptable rates. This suggests a move away from judging you on your own merits, your education, your job offer, your sponsor's income, and instead judging you based on the statistical behavior of other people from your country who are already in the U.S. This is collective punishment masked as fiscal responsibility, and the document states the freeze is indefinite. Indefinite is the scariest word in immigration law because it means there is no sunset clause, no expiration date, and no specific benchmark for when the doors will reopen. We need to break down exactly which countries are in the crosshairs because the list is extensive and, quite frankly, shocking in its composition. According to the list released by Fox News based on the internal documents, we are talking about nations that have historically had close ties with the United States. In the Caribbean, we are looking at a near-total blackout. The Bahamas, Barbados, Jamaica, Haiti, Grenada, St. Lucia, St. Vincent, and the Grenadines, Antigua, and Dominica are all on this list. Think about the implications of that. Jamaica, a country with deep economic and cultural ties to the U.S., a country that just recently faced a humanitarian crisis with hurricane damage, is now facing a total suspension of immigrant visas. In Africa, the list includes major hubs of immigration like Ghana, Nigeria, Kenya, Ethiopia, Cameroon, Liberia, Senegal, Somalia, and Uganda. In Eastern Europe and Asia, we see Albania, Bosnia, Moldova, Montenegro, Russia, Georgia, Uzbekistan, and Pakistan. This is not a random selection. This is a targeted list that encompasses a massive percentage of the developing world. And yet, notably absent are countries like China and the Philippines, raising serious questions about the geopolitical and perhaps racial motivations behind the selection of these specific 75 nations. It is absolutely critical to clarify what this pause actually means, because panic often leads to misinformation. This suspension targets immigrant visas. In immigration law terms, an immigrant visa is specifically for someone trying to move to the U.S. permanently, someone applying for a green card to live here forever. This includes the spouse of a U.S. citizen, the parent of a U.S. citizen, the child of a resident, or a worker coming for a permanent job. It does not currently apply to non-immigrant visas. If you are applying for a B1, B2 visitor visa to go to Disney World, or an F1 student visa to attend university, or a J1 exchange visa, you are currently not on this list. The government has not paused temporary travel. They are specifically targeting permanent relocation. So if you are a student from Ghana or a tourist from Jamaica, the doors are theoretically still open for you to visit, provided you can prove you intend to return home. But if you are a grandmother from Jamaica trying to reunite with your U.S. citizen son permanently, the door is slamming shut on January 21st, 2026. This distinction is vital, but it offers little comfort to families who have been waiting years, sometimes decades, for their priority dates to become current. We are talking about the I-130 family petitions and employment-based sponsorships that form the bedrock of our legal immigration system. The government is effectively saying that even if you have a U.S. citizen petitioner, even if you have paid every fee, even if you have a clean background check, if you hold a passport from one of these 75 countries, your application is going into a deep freeze indefinitely. We have to look back at history to understand how this plays out. In 2020, we saw a global suspension of visas under the rationale of protecting the labor market during the health crisis. That suspension created a backlog that we are still digging out of today. This new suspension, based on public charge, could create a backlog that lasts for a generation.
And unlike the 2020 ban, which had a clear link to a temporary global emergency, this ban is based on economic ideology, which is much harder to cure. How does a country prove that its citizens will stop using welfare? What is the metric for lifting the ban? The internal documents reportedly say the freeze remains until the U.S. can ensure new immigrants won't extract wealth. That is an impossibly high bar to clear, suggesting this could be a long-term, structural change to American demographics. Now let's talk about the legal reality on the ground. Whenever the executive branch takes a sweeping action like this, litigation is inevitable. We expect major civil rights organizations, immigration advocacy groups, and the American Immigration Lawyers Association to file injunctions almost immediately. Federal judges have the power to block these types of executive actions if they are found to be discriminatory or if the government failed to follow proper administrative procedures. However, litigation takes time. It can take weeks, months, or years for a case to work its way up to the Supreme Court. In the meantime, families are left in limbo. If you have an interview scheduled for after January 21st, 2026, you should be prepared for a cancellation notice. In the past, when these suspensions hit, the State Department didn't just hold the applications. They physically refused to issue the visa foils and passports. You could go to the interview, pass the medical, pass the background check, and the officer would hand you a piece of paper saying, "Administrative processing" or "suspended under presidential proclamation." It is a devastating emotional blow, and we want you to be prepared for that possibility. There is, however, a very significant strategic angle that we need to discuss for those of you who are currently inside the United States or have the ability to enter the United States on a temporary visa. This suspension applies to consular processing. That means getting your visa at a U.S. embassy abroad. It does not, as of this moment, apply to adjustment of status for people already physically present in the United States. This is a critical loophole. If you are currently in the U.S. on a valid visitor visa or a student visa, and you have a U.S. citizen immediate relative, like a spouse or an adult child, you are eligible to file for your green card from within America. This process, filing forms I-480 and I-130 concurrently with USCIS, is separate from the State Department's visa issuance abroad. Historically, when bans are placed on entry, they often do not affect those already here. So if you are a national of one of these 75 countries, say Brazil or Nigeria, and you are currently in the U.S. visiting family, and you were planning to go home to wait for your visa, you need to speak to an attorney immediately. You might have the option to change your plans and adjust your status here, thereby bypassing the overseas suspension entirely.
However, we must issue a stern warning regarding this strategy. We are watching closely to see if USCIS, the agency that handles immigration inside the borders, will align its policy with the State Department. It is entirely possible that the administration could issue a follow-up directive ordering USCIS to also pause adjustment of status cases for these same 75 countries under the same public charge rationale. We have not seen that order yet. As of right now, USCIS is still processing applications, but in this climate, policies can change overnight. Furthermore, you must be careful about immigrant intent. You cannot enter the U.S. on a tourist visa with the preconceived intent to stay forever. That is visa fraud. However, U.S. law recognizes that circumstances change. If you entered lawfully and then, after being here, decided that you cannot bear to be separated from your family or that the situation back home has changed, you are allowed to change your mind.
This change of intent doctrine is complex, and you absolutely need legal counsel to navigate it. But it may be the only lifeboat available for thousands of people facing this indefinite freeze.
Let's look deeper at the list because the geopolitical confusion is real. Why is Uruguay on the list? Why is Mongolia? Why is Russia included, but not Ukraine? The inclusion of Russia is significant given the current global tensions, but the inclusion of friendly nations like Ghana and Jamaica is what makes this policy so aggressive. It signals a move away from diplomacy and toward a purely transactional view of migration. What do you cost us? Versus, what do you contribute? This narrative that immigrants are extracting wealth is one that economists have debated for decades, with most studies showing that immigrants actually contribute more to the economy than they take, especially when you factor in the labor shortages in key industries like healthcare, agriculture, and technology. By shutting down the labor pipeline from 75 countries, the administration is risking labor shortages in critical sectors.
Think about the healthcare sector, which relies heavily on nurses and doctors from countries like Nigeria and the Philippines. While the Philippines is off the list, Nigeria and Ghana are on it. This could have a ripple effect on the American economy that the authors of this policy may not have fully calculated.
We also need to address the I-601A waiver applicants. These are people who are in the U.S. undocumented but are married to citizens, and they need to leave the U.S. to get their visas abroad. They have been waiting years for provisional waivers to be approved so they can travel without being barred from returning. If you are in this category, and you are from one of the 75 countries, leaving the U.S. right now is incredibly dangerous. If you leave to attend an interview in a country where visa processing has been suspended, you could find yourself stuck outside the United States, separated from your family, with no way to return and no visa being issued. If you have an approved waiver and an interview scheduled, consult with your lawyer before you get on that plane. The risk of being stranded is higher now than it has been in years. The same logic applies to anyone with a pending case. Do not travel internationally if you don't have to. The borders are fluid, policies are shifting, and you do not want to be on the wrong side of the border when a new executive order drops. It is also important to debunk some of the rumors swirling around this announcement. We have seen people asking if this affects DACA renewals. No, DACA is a separate domestic policy and is not related to consular immigrant visa processing. We have seen questions about asylum seekers. While the southern border policies are restrictive, this specific order is about visa processing at embassies, not asylum claims at the border, though the administration is undoubtedly tightening asylum rules separately. We have seen questions about the K-1 fiancé visa. This is a gray area. Technically, a K-1 is a non-immigrant visa, but it has immigrant intent. In past bans, K-1s were often lumped in with immigrant visas because the ultimate goal is a green card. We are waiting for specific guidance from the State Department on whether fiancé will be spared. Until we see that guidance, K-1 applicants from these 75 countries should proceed with extreme caution and prepare for delays. Let's address the emotional toll of this. We know many of you watching Immigration News Desk have spent thousands of dollars on fees, undergone medical exams, and put your lives on hold waiting for that interview letter. To hear that your country has been placed on a suspend list is devastating. But we want to remind you that in immigration law, nothing is permanent. Administrations change, lawsuits result in injunctions, and policies are rescinded. The most important thing you can do right now is not to withdraw your application. Keep your place in line. If you have an I-130 pending, let it process. If you are at the NVC stage, keep submitting your documents. Do not self-deport or give up your spot. When the suspension is lifted, and history tells us it eventually will be, either by the courts or a future administration, you want to be ready to move. The people who panic and withdraw their cases are the ones who lose out in the long run. For those asking about specific countries not mentioned yet, let's clarify a few more. Mexico is reportedly not on this specific list of 75, which is surprising given the volume of migration, but Mexico has its own set of bilateral agreements and separate border enforcement policies. India is reportedly not on the list, which is a massive relief for the tech sector and H-1B to green card pipeline. Canada, the UK, and Australia are not on the list. This reinforces the perception that this policy is targeting the global south and developing economies under the guise of welfare prevention. It creates a two-tiered system of immigration where applicants from wealthy nations are fast-tracked, while applicants from developing nations, even those with sponsors and job offers, are viewed with suspicion and blocked. We also need to touch on the Diversity Visa Lottery, or DV Lottery. Winners of the Diversity Lottery from these 75 countries are effectively out of luck if this ban goes into effect. The DV program has strict deadlines. Visas must be issued by the end of the fiscal year. A suspension like this, even if it only lasts a few months, could run out the clock for thousands of lottery winners who beat the astronomical odds to win, only to be blocked by this new policy. This happened in 2020 as well, and it resulted in massive lawsuits. If you are a DV winner from a listed country, your window is closing rapidly, and you need to watch the litigation closely as your only hope may be a court order forcing the government to process your case. We are also monitoring the situation for conditional residents. Those of you who already have your 2-year green cards and are filing to remove conditions, Form I-751. You are safe. You are already permanent residents. This policy blocks entry. It does not strip status from those who already have it. Similarly, naturalization applicants, Form N-400, are safe. This is a border control measure, not a domestic enforcement measure against current residents. However, if you are a conditional resident, this is yet another reason to file for citizenship as soon as you are eligible. A U.S. passport is the only true shield against these shifting executive policies. As long as you are a green card holder, you are subject to the whims of changing immigration enforcement. As a citizen, you are protected. So, what is the action plan? If you are watching Immigration News Desk tonight and you are from one of these 75 countries, here is your checklist. Number 1. Verify your priority date. If you are current and in the U.S., consult a lawyer about adjustment of status immediately. Number 2. If you are outside the U.S., ensure your contact information with the National Visa Center is up to date so you receive notifications instantly. Number 3. Do not travel outside the U.S. if you have a pending status here. Number 4. Prepare your sponsors. The government's attack is on public charge, so having a sponsor with strong financials is more important than ever. You may want to consider getting a joint sponsor even if you technically qualify with just one, to create a bulletproof financial file that rebuts the presumption that you will use welfare. Over-documenting your financial independence is your best defense against a public charge accusation. This news is heavy, and it is frightening, but knowledge is power. The government relies on people being uninformed and missing deadlines. By being here, by subscribing to Immigration News Desk, you are arming yourself with the intelligence you need to navigate this hostile landscape. We will be monitoring the Federal Register and the State Department's press briefing room every single hour for the official publication of this rule. We are specifically looking for the exceptions list. Usually these orders have exceptions for national interest, for healthcare workers, or for cases involving extreme humanitarian hardship. Once that criteria is published, we will break it down for you so you can see if you qualify for a waiver of the suspension. In conclusion, we are facing a potential freeze of immigrant visas for 75 countries, including major nations like Brazil, Jamaica, Pakistan, Ghana, and Russia, effective January 21, 2026. The rationale is public charge, the fear of migrants using welfare. The suspension is indefinite. However, student visas and tourist visas are currently exempt, and adjustment of status within the U.S. remains a viable pathway for now. Litigation is expected to challenge this order immediately. We know this is not the news you wanted to hear, but we are committed to standing with you and providing the strategic guidance you need to survive this administration's policies. We will get through this, just as we have gotten through previous bans and suspensions. Stay strong, keep your files organized, and do not let fear paralyze you into inaction. Thank you for trusting Immigration News Desk with your time tonight. Please share this video with your community groups, your WhatsApp chats, and your family members abroad. They need to know what is coming so they aren't blindsided at the embassy. We will be back with another update as soon as the official text of the order is released. Until then, stay informed and stay ready.